lots of questions for them. Today's event is sponsored by the Duke Law ACLU and the Death Penalty Reform Group, as well as the the Duke Bar Association. I have a quick announcement about another upcoming event that some of you all might be interested in. Professor Ken Cook from the Public Policy School is going to be speaking on November 13th. 10 years ago, he did research showing that the death penalty is more expensive than life in prison, and he's currently redoing that study, and we'll be here to talk about it. So that, again, that's November 13th. And also, there's going to be a sign-up sheet for the Death Penalty Reform Group going around the room during today's presentation. I'm glad you all could join us. We have two very distinguished guests today. The first I'll introduce is Mark Kleinschmidt. Mr. Kleinschmidt is the Executive Director of the Fair Trial Initiative, where he represents several North Carolina capital defendants in post-conviction work and recruits and mentors recent law school graduates interested in becoming capital trial attorneys. Prior to joining the Fair Trial Initiative, he spent 6 years as a staff attorney at the Center for Death Penalty Litigation, where he represented 9 members of North Carolina's death row and consulted in dozens of other capital cases. He also played a central role in developing best practices for representing capital defendants suffering from mental retardation. In addition, Mr. Kleinschmidt is a member of Chapel Hill's Town Council, currently serving his second term. He served on the boards of numerous organizations, including the North Carolina American Civil Liberties Union, the International Network of Lesbian and Gay Officials, and Equality North Carolina, and he's a member of the North Carolina Democratic Party's State Executive Committee. Professor James Coleman teaches criminal law, wrongful convictions, legal ethics, and negotiation here at Duke Law. He's the faculty advisor to the school's Innocence Project and taught the Death Penalty Clinic, which assisted North Carolina lawyers in post-conviction cases. While a partner in Wilmer, Cutler, and Pickering, Professor Coleman represented 2 Florida death row inmates, Stephen Todd Booker and Ted Bundy, in post-conviction cases. Booker's death sentence was overturned, Bundy's was not, and Professor Coleman was a witness to the execution. Professor Coleman was chair of the American Bar Association section of Individual Rights and Responsibilities and one of the major forces behind the ABA's 1997 resolution calling for a moratorium on executions. He also chaired the ABA's Death Penalty Moratorium Implementation Task Force, which recently completed an assessment of the death penalty in 8 states. He's been active in moratorium efforts in North Carolina, and he's currently assisting with a clemency petition for Guy LeGrand, a death row inmate who showed clear signs of mental illness while representing himself at trial. Professor Coleman testified at an evidentiary hearing seeking to have LeGrand declared incompetent to be executed. The judge has not yet made a decision, so I hope you all welcome Mr. Kleinschmidt and Professor Coleman.
Shall I begin? Thank you. Thank you very much for that very comprehensive introduction, Lisa. She said I'm the Executive Director of the Fair Trial Initiative. I've been practicing only for 7 years. I graduated from UNC down the street, and I've exclusively practiced in the area of capital defense work and post-conviction work. I just thought I'd tell you a little bit about where we are here in North Carolina right now. We have about 166 members of North Carolina's death row, all of them men, well, except for 4. There are 4 women. This year, there have been 3 death sentences handed down by North Carolina juries. In a state like Connecticut, that would be headline news, front page above the fold. I think it probably should be that way here in North Carolina as well, considering it was just a decade ago that we were sending a new person to death row on average, every other week. And that's how our death row became as large as it is, and was at one time the third largest death row in the United States, and when it peaked around 225 about 6 years ago. The numbers have come down for a couple reasons. One, because of changes in the law that have allowed for members of North Carolina's death row to receive sentencing or guilt phase relief, allowing for new sentencing hearings and new trials. Many of them associated with the Atkins ruling, which is the U.S. Supreme Court case that barred and banned the execution of people with mental retardation. A couple people have come off because of the Roper v. Simmons case from just a couple years ago that banned the execution of individuals who committed their crimes prior to the age of 18. But the vast majority of the cases that have received relief over the last 7 or 8 years have been due to a real change in the standard of practice here in North Carolina. And I think it's not only leading to relief for death row inmates and new sentencing opportunities, but also is responsible for decreasing the number of people being sent to death row generally. Back around the turn of the century, this current century, the U.S. Supreme Court suddenly became interested in death penalty again. And they began to express concern through a series of cases about the preparation of trial lawyers and how they approached the practice at trial. In a series of cases, beginning with Terry Williams' case from Virginia, the Wiggins case followed up a couple years later from Maryland, and then the Rompilla case from Pennsylvania. They began to set standards for what trial lawyers need to do during a capital trial and why those cases are different than regular trials. If you have an interest in being a trial lawyer, I'm sure it developed similarly to the way my interest in being a trial lawyer developed, which is watching television and watching these courtroom dramas and how exciting that is, to see, to watch the practice and watch them stand and their great posture and the great use of the language and the arguments with the district attorneys and the judges. It's exciting. And the goal always was a not guilty verdict. And that really defines the state of practice for criminal defense lawyers in many ways, or at least it's the thing that brought us to that point, brought us to the profession. In capital trials, when a case gets to that point where it's actually going to trial, it's a rare case when during the guilt phase of trial, a jury returns a not guilty verdict. It's very, very rare. And it's a celebrated a case when that happens because the jury's saying he's not guilty. Thank goodness they didn't go to a sentencing phase. But that mindset towards securing a not guilty verdict has often prevented trial lawyers from preparing for the sentencing phase. The phase of a trial where you ask a jury to impose life instead of death. And the failure to prepare adequately for that is what led to the Supreme Court cases over the last 7 or 8 years that drew upon the ABA standards for how capital lawyers should behave, which require extensive investigation of potential mitigating factors. It used to be that once upon a time you throw the defendant's mother on the stand and have her cry and beg for mercy. Well, that's just inadequate. And we've learned that when you tell juries about things like brain damage, when you explain to them the consequences of a lifelong addiction to substances, alcohol and drugs, and how that affects brain development, particularly when it begins in adolescence, and you apply the new science of neurology and neuropsychology to understanding who the defendants are, then you're given the jury a real opportunity to decide, is this person the kind of person we want to kill, or is this the kind of person that we want to spend the rest of their life in prison? And now the lawyers are doing better jobs. We're getting new sentencing hearings for people so that we can finally present that to a jury, sometimes decades after they were first convicted. And now we're doing a better job at trial, presenting it in the first instance, and jurors are refusing to impose death. In some cases that are just, that stand in stark contrast to some of the facts in other cases. You hear all these cases about people committing these horrible crimes, and there are multiple murders, children being killed, old people being exploited and murdered, and then they're not ending up on death row. The overwhelming majority of people who are on death row in North Carolina, and I would argue probably across the country, for each one of them there's one murder, there's one dead person. Now I understand that's enough certainly to punish somebody, should they in fact be guilty. I'm not arguing that everyone gets a free body. But there's a lack of consistency in applying the death penalty, the kinds of cases that are out there. The Green River Killer in Washington State is spending the rest of his life in prison. Moussaoui is going to spend the rest of his life in prison. Yet, my client from Winston-Salem, who after a horrible childhood that was marked not because his parents were horrible to him, but because of the mental illness that had gone undiagnosed for more than 10 years, beginning at the age of 8. When he was 19, killed his aunt and sold her car to escape not only a community that wasn't providing services for him, but the demons in his life that were associated with his home, and the story that was really never presented to a jury. He's on death row, but the Green River Killer is not. The BTK killer is not. What's that about? Then finally, when in this practice, particularly at Fair Trial Initiative, not only do I get to represent people on death row and then also train new lawyers like yourselves to be capital defense attorneys, we also have a role we participate in developing the public policy of the state in how we approach the death penalty. This last legislative term saw some wonderful changes to the way the police handle criminal cases that are going to, we believe, have a significant impact not only on capital cases but on all criminal cases. New laws that are now requiring the recordation of defendant statements, and new rules to protect, to make lineups more fair and reliable. They've passed, both houses have been signed by the governor, and signed into law by the governor. Still on the agenda for the legislature in the short session coming up are 3 really very important bills, 4 actually, a true legislative moratorium, and my 2 cents is that's unlikely to pass, but the 3 others that have a good shot. One, the first in the nation ban on the execution of people with severe mental illness, a racial justice act that will allow for real evidence of racial discrimination to be presented to a court, and a bill that would require the North Carolina Supreme Court to examine each case for proportionality, so that we can look at all first-degree murder cases and protect against arbitrary application of a death penalty. So whenever those weird cases that don't seem, it defies common sense to say that they're the worst of the worst when we're looking around seeing these objectively more horrible crimes, to actually allow the Supreme Court to say, you're right, this case is not one of those, and we're going to say so, and we're going to vacate the death sentence. It's a requirement of the North Carolina Supreme Court to do that analysis, but they've restricted themselves to only comparing capital cases to death cases. They're not comparing a given death penalty cases before them to the scores of worse cases that are getting life. They only compare the instant case to other cases that had received death. And it's leading and has led to extremely arbitrary results. So that bill we hope to get through the North Carolina Senate. It's already passed the House this past summer. I look forward to answering questions you might have, and I anticipate that you might have some questions about lethal injection, which is the big issue in the United States right now. I represent Jerry Connor, who's the named plaintiff in the lawsuit against the Council of State, and we have a lethal injection claim, 1983 claim, in front of a federal judge in the Eastern District of North Carolina that has been put on hold for because of the ongoing state litigation that we're involved in. And I'd be happy to talk about that. But before I just continue to ramble, I'll let Professor Coleman jump in, and then we can talk about lethal injection if you want.
Okay. I'll be brief. I think that in the 10 years that I've been here, that there's been enormous changes in the death penalty in North Carolina. I think Mark has mentioned most of them, but I think that we've gone from a period where we were on a per capita basis sentencing a large number of people to death row, and I think that's very noticeably changed in the last few years. This is an area where people both here at Duke and at UNC have been fairly prominent in a lot of the efforts that have been going on. Bob Mosteller Cindy Adcock, and I have been involved in efforts relating to the death penalty here at Duke. Rich Rosen and Jack Boger at UNC have been very prominent in efforts. The Fair Trial Initiative, which is an organization that was established in order to bring young, lawyers from top law schools into capital defense work, was started by two UNC law graduates and Zephyr Teachout, who is a graduate of this law school and who's here now as a visiting associate professor. They were recently graduated from law school and thought that one of the things that was necessary if we were going to improve the quality of counsel in capital cases was that we were going to have to attract young lawyers into the field, and the Fair Trial Initiative was established to do that, and it's done a really outstanding job. I think that what's had the greatest impact, I think there are two things that have had a really great impact on the death penalty in the country and in North Carolina as well. One is the Moratorium Effort, which probably got off the ground in 1997 when the American Bar Association passed a resolution calling for a moratorium on executions. Others had talked about it, but the ABA, which at the time was not viewed as a liberal left-wing organization, although it's been called that, that's not an accurate characterization of the organization. But overwhelmingly, its members passed a resolution calling on states to impose a moratorium on executions so that the flaws in the system could be remedied, addressed. And the ABA was concerned about 4 or 5 different issues. It was concerned about, as Mark pointed out, the woefully inadequate counsel appointed in capital cases. And you've heard all the horror stories about lawyers, sort of the dramatic ones, but on the whole, lawyers who simply had no business representing a defendant in a capital case, because as Mark pointed out, the real trial in a capital case is for life, that is for the penalty phase of the trial, not so much the phase of the trial to determine guilt or innocence. The key and the real work has to be done once the defendant is convicted in a capital case and then has to put on a case for his or her life. And that's where the lawyers fell down. Another issue was independence of the judiciary in reviewing capital cases. We went through a period of time when politically it was almost a death sentence for a judge to vote against a death sentence or to vote to return a death case for further review by lower courts. Beginning with Chief Justice Rose Byrd in California, there have been a series of state Supreme Court justices who were defeated as a result of their decisions in capital cases. So the concern was that the judges were reluctant to review these cases independently. Two other issues that the ABA was concerned about was the fact that we were one of the few countries to execute offenders with mental retardation. Another was that we were one of the few countries in the world to execute juveniles. The Supreme Court finally decided that both of those things were unconstitutional. And so, we're no longer doing it, and that has had an impact too. But I think that what caused the Supreme Court to sort of re-engage with the death penalty was that it appeared that the public was concerned about how it was being administered. And that was the whole point of the ABA effort. It was that we were not making progress to try to abolish the death penalty. I mean, we weren't convincing people that the death penalty should be abolished. Even today, the numbers in terms of polling of people who support the death penalty is extremely high. Even though it's decreased, it's still very high. And in the debate about whether there ought to be a death penalty or not, people were just talking past each other. I mean, we weren't listening to what anybody had to say, and so there was no progress was being made. What we decided to do in 1997 was to change the focus of the debate from whether there ought to be a death penalty to how is the death penalty administered. Because what we thought was that if we could change the focus of the debate so that the public focused on how the death penalty was being administered, the kinds of errors that were being made, and the prospect that if we continued to administer the death penalty in the way that it was being administered, that we at some point would execute an innocent person. That sort of got everybody's attention. And that was the sort of second major development that I think has contributed to what's happening with capital sentences, which is that I think the public now is convinced that the system is far from perfect and that we are making mistakes in convicting people. We are convicting a relatively large number of people, that is relative to what anybody would have expected. Relatively large number of innocent people are being convicted for very serious crimes and put in prison, and in some cases sentenced to death. I think that gave the public pause about the death penalty, and once the public becomes concerned about it and concerned about whether juries are condemning an innocent person, then obviously jurors become concerned about that. And with improved lawyering, I think what we've seen is that juries are reluctant to sentence people to death, both because they have a better view of the defendant because of the better lawyering, and also I think because of their general concern about whether the system might result in the miscarriage of justice in a particular case. One of the things that in 1972, when the Supreme Court declared the death penalty unconstitutional, two of the justices, Marshall and Brennan, took the position that the death penalty was unconstitutional under all circumstances. The difference between the two of them was that Justice Brennan thought that the evidence, that there was evidence that the public had rejected the death penalty, and he based that on the fact that only poor people and minorities were sentenced to death, and that the public seemed reluctant to sentence others to death. Justice Marshall agreed with that, but the focus of his opinion was on the fact that he didn't think the public understood what was involved in the death penalty. And he felt that if the public knew more about the death penalty, knew more about how it was administered, knew more about how it was carried out, that the public would turn against it. And I think at the time, a lot of people thought that this was kind of pie in the sky, which was surprising coming from a person with the experience that Justice Marshall had actually defending capital cases. But it turns out that he was right. And I think that that's what we're seeing now. I think we're seeing that with the lethal injection. We saw it earlier with the electric chair when the Supreme Court appeared to be ready to step in because of several botched executions, most prominently one in Florida. And it appeared that the court might be ready at that point to declare the electric chair unconstitutional. States then switched to lethal injection. There was an attack mounted on that, and now that issue is before the Supreme Court. I think in terms of the law, where we're headed is that I think the evidence is beginning to mount for a sort of another frontal attack on the death penalty, the argument being that there are so many problems with how is it administered and so few death sentences being imposed that it has become cruel and unusual and arbitrary, and that it ought to simply be declared unconstitutional. The Second Circuit several years ago, actually not the Second Circuit, but a judge in the Second Circuit, a federal judge, declared the death penalty unconstitutional on that basis. It was reversed by the Second Circuit. But I think that we may be headed for that, that claim being resurrected. And, my guess is that there are probably 4 votes on the Supreme Court for that position now, and we'll see. Anyway, why don't we open it up to questions and see what you want to talk about. Go ahead.
Yeah, I just have a question, 2 questions really. One is if you could just expand a little bit more on sort of the disparate impact of death penalty on poor folks and minorities. I know that it definitely, or I'd heard that it, was the case that minorities were sentenced to death than other folks, and I was wondering if that, if that's still the case. And then if you wouldn't mind, I'd like to hear from both of you as to your personal philosophies on the death penalty. I know that it is a personal issue, and if you don't feel comfortable discussing it, that's fine. But if you wouldn't mind just talking about that.
Okay, for me to take the first one. On the sort of racial disparity in how the death penalty is administered, it's probably a little counterintuitive what's going on. Before 1972, what was going on was that primarily African-American defendants were being sentenced to death in grossly disproportionate numbers and for different crimes. I mean, for example, when the death penalty before 1972 was available for rape, and almost all of the people who were executed for having committed rape were black, and their victims were white. Since 1972, or since 1976, when the death penalty was reinstated, the statistics suggest, and this isn't true in all jurisdictions, in some jurisdictions, the pattern remains the same. In Philadelphia, for example, it continues to be the case that minority defendants are disproportionately sentenced to death. But what the sort of larger impact of race is race of the victim. And that is that the death penalty is being used when white people are victims of the crime. And there have been studies, beginning with an early Baldus study, which got to the Supreme Court, in which they showed that if your victim was white, you were 4.5 times more likely to get the death penalty than if your victim was not. And that's also an old pattern that was true during slavery, which was that the death penalty was being used basically to protect white people from the conduct of black people, slaves. But that now is kind of the focus of race in the death penalty. It is the race of the victim that's sort of the driving force.
And those studies were reaffirmed in early part of this decade, a study that Jack Boger did at UNC that confirmed it, and I think he found 3.5 times more likely here in North Carolina. So it's functioning the same way here.
Is that the same for low-income poor folks? I mean, if there is disparity, is that the same reason for the disparity? Because more of the relative wealth of the victim rather than the defendant.
Well, that's a function of who gets the death penalty. That is, that if you can't make an effective case for your life, then jurors are. So these are people who did not have very good lawyers, who are not telling very good stories about why their life should be spared, and so the penalty phase became almost perfunctory. I think that's beginning to change now.
And back when, I always hesitate to condemn court-appointed lawyers because I'm appointed in all the cases I'm on. But prior to North Carolina's Indigent Defense Service being the institution that did all the appointments in capital cases, the courts appointed local attorneys, and you either got who was on the list, who was next on the list, or you had to hire somebody else. And there were the standards basically were 5 years of practice and the judge wants to appoint you. And so what if you've just been doing T&E and divorces and stuff? If you want to do one, you can do one. And so, that really set up a disparity between those who had resources and those who didn't. And I think, but I didn't think it functioned that you actually saw people who could hire their lawyers actually not receiving the death penalty. I think what you had in those, what the more common result was that it ended up at negotiating out to something less than even going to trial. So you're not going to see these numbers with wealthy individuals being charged with crimes where they're receiving life. I mean, even Michael Peterson here in Durham, he wasn't tried for his life. He did, in fact, he actually retained his attorneys. There is only one advanced degree that I know of on death row in North Carolina. There's a dentist. But beyond that, you have a couple people with some college. But to be honest, high school diplomas are and lower are the rule. And the accompanying, the predictable socioeconomic status of the people given their education is exactly what you think it would be. So.
You want to address the second part of his question?
My opinion on the death penalty? I came to the work because I was opposed to the death penalty. I developed it in 8th grade when I was assigned to be anti-death penalty, even though I professed to be for the death penalty, but my teacher assigned me the anti-death penalty side of the debate. And, so this was only in like 1982 or something, and the little bit of research that had been done on the disparity of application of the death penalty and the kinds of cases that convinced me then, and nothing has been persuasive enough for me to rethink that position since I was in 8th grade. So I just have moral opposition to it.
Yeah, I guess I sort of came to the position of opposing the death penalty after I did my first death penalty case in 1983. Before that, I didn't really pay much attention to the death penalty one way or another. I had no interest in criminal law at all, and
Wait, you were doing your first capital case in 1983, and I was doing an 8th grade debate on the death penalty in 1983.
I know, it just gets worse. But in 1983, I agreed to become counsel in a case in Florida for a guy by the name of Stephen Todd Booker, who was the first Florida case that had gone through one round of habeas and was a successor. And everybody thought that he would be executed, and we didn't know better, so we went to Florida thinking we would save his life. I was shocked by the attitude that the prosecutors and the judges had about the case. I mean, they had no interest in it at all, and we had some legitimate claims. In fact, we had claims that the judge acknowledged were not frivolous, but they treated them like they were frivolous. And that just surprised me. I mean, I was at a big law firm where, we would spend, 10 years on some meaningless civil shipbuilding case that nobody, ever remembered until, 10 years later, and somebody decided we should settle it to just get rid of it. But, this was a case where the judge, we went through all of the state courts. We got to the 11th Circuit in like 3 days with full evidentiary hearings, put on experts. I mean, it was the most extraordinary thing I had ever seen. And I decided at that point that the prosecutors and the judges were not taking seriously their obligations in these cases, and that they were making mistakes, and that it wasn't likely that that was going to change. I've since also just reached the view that it's an unfair system, and there's no way really to remedy it or to reform it. So I would change the name of organization and forget about reforming it. I just think that's not really possible.
I should say that my organization, at the direction of my board of directors, does not have an opinion on whether or not the death penalty is it could ever be an appropriate sentence for a particular case. What the Fair Trial Initiative does is to work to ensure that as long as we have one, that we continue to work to make sure it's as fair as it can be. and I sit here today, and I'm sure I will tomorrow as well, declare that we have not succeeded yet. And so, yeah.
Professor Coleman, I was surprised when Lisa mentioned at the beginning that you started doing some of this work while you were at Wilmer-Hale.
Yeah.
Whatever it's called then.
Yeah, Wilmer-Hale, right.
And it sort of surprised me that's where that work began. And I'm kind of curious, especially now that 1L Career Palooza has started, sort of what opportunities are there for people who are interested in working at those type of firms but are very passionate about these issues, and how in your career experience you're able to reconcile sort of those two things. And you were talking about reaching out to young attorneys to get them involved in this kind of work. Is it just an attempt to get young attorneys to commit themselves completely to this line of work, or can you sort of do both things?
You want to answer that?
We try to train people to be great capital trial lawyers here in North Carolina. I mean, our mission is focused on improving the state of the capital bar. So that's what we do, but we do offer other kinds of program. We have summer programs, for example, and we've yet to have a summer student come back as a fellow. But nonetheless, we've given them an experience that we think they're taking on to their big firm work. And there are opportunities in particular firms to get involved in habeas work. When I was at the Center for Death Penalty Litigation, I did the summer program for our students there, and many of them have gone on, graduated from law school, got the big firm jobs in Chicago and New York and all over the country, and they targeted their pursuit of firms that had active participation in death penalty cases. See, there's one state in particular, Alabama, does not have a right the defendant doesn't have a right to post-conviction lawyers. Here in North Carolina you do, but in Alabama you don't. They have a lot of people there who don't have attorneys. And Brian Stevenson, New York University School of Law, has set up the Equal Justice Initiative in Alabama, and he represents a lot of people. But he also, and others with his help, recruit these bigger firms with other resources, but in Washington, D.C. and in New York and other places, to work on some of these Alabama cases. So I was recruiting in Chicago in August, and it was table talk time, and so I'm sitting next to this big firm next to me, and they sent 2 young associates to do the table talk. And they asked me who I was and what I was doing. I told them. And one of the young associates was like, "Oh, wow, I work on an Alabama habeas case." I'm like, "Really?" She's she's working in Chicago. And it was astounding to me because they had a team of 15 attorneys in the firm who were assigned to this one habeas case. I'm like, wow, I have one co-counsel and an investigator. But their opportunities are out there.
Yeah, I mean, there are a lot of particularly the larger law firms in D.C., Chicago, New York, San Francisco, L.A., who handle these cases. But primarily on the East Coast and Chicago, it's not uncommon at all to see the large law firms involved in the major cases. One of the Supreme Court, when it decided the Atkins versus Virginia case, which is the mental retardation case, originally granted cert in a case here in North Carolina that had been a case in the death penalty clinic, and the student who worked on it was at Wilmer, Cutler, and Pickering after she graduated, and continued to represent the client pro bono there, and they filed the cert petition. It was granted, and then North Carolina changed its law and legislatively barred the death penalty for people with mental retardation, and so they dismissed the case as moot. But so there are a lot of opportunities to work on these kinds of issues, both directly the way Mark does, or to do it through pro bono efforts at some large law firms.
I guess this is a North Carolina-centric question, but I grew up in Cumberland County where my father did death penalty work, and then have spent the last 5 or 6 years living in Orange County, and it's almost like there's a completely different attitude towards the death penalty, and the application of the death penalty seems, just on my anecdotal experience, to completely I don't know, like for example, I don't know when was the last time that they even sought the death penalty in Orange County. murder case or serious offense, but could you talk a little bit about the geographical lay of the land just in the application in North Carolina or even politically? Like, are there certain hot spots for the death penalty that are turning out more of the cases in other areas of North Carolina where it's not ever applied at all or not ever sought?
Yeah, I mean, what you're doing is you're speaking the truth about it, these geographical disparities. In Orange County, former district attorney Carl Fox, who's now a Superior Court judge, and a lot of people don't realize, did pursue the death penalty 8 times while he was there. And his prosecutorial district was Orange and Chatham County. Now, compare those 8 times to his very long career as district attorney. I think it may have been almost 2 decades. In Buncombe County, now that's Asheville, North Carolina, generally has a very liberal reputation. People think of it as, hippies in the mountains, right? Has probably the highest per capita membership on death row vis-a-vis the population of Buncombe County. They have a district attorney there who has pursued it, I couldn't tell you how many times, but it would have to be at least 10 times more often than Carl Fox did in Orange. I keep a map, we keep a map in our office that shows where all the cases are in North Carolina, the people on the row. But we put little flags in them, and there's not any more room in Buncombe County for another flag. Forsyth County, Winston-Salem, is also a hotbed. But there haven't been death cases in those areas in a long time. New Hanover County in Wilmington in this decade has been one of the, it's been a leading county with 4 new death row cases since 2000, lots of other capital prosecutions. There hasn't been a death sentence in Cumberland County in quite some time. But you look at places like Mecklenburg County, the city that leads the state in population, Charlotte, and I think there are 4 people on death row, and there are more than 1 million people in the county. And you look at Asheville, and it has the biggest city there. The biggest city has 65,000 people in it, and there are like 12. But it depends on who the district attorney is and what role the death penalty plays in local politics. And it's not just the DA. I'm not going to leave the judges off the hook because they also play an important role in making sure that death sentences are actually brought down. Yeah.
I just wanted to learn more about sort of what your ultimate goal is in the challenge to the lethal injection that you guys have in the courts. I mean, if North Carolina came out with a system tomorrow that said, okay, we figured it out and they're dying without pain, would you guys be okay with that, or is it really sort of a sideways attack on the death penalty, saying, look, you can't do this without pain, therefore you should toss it out?
Well, I think the evidence that's been, we have the same cases going on here in North Carolina as are going on in Kentucky, and that case just got its cert granted. So they're pretty analogous, and we all have the same experts and everything too. But the experts that that we've talked to have a history both in in how these chemicals work and operate, as well as some who have expertise in veterinary science. Where often it's the job to kill the living thing. Our experts are confident that there are unreasonable risks involved with the lethal injection protocols as they're written in Kentucky and here in North Carolina. The risks come in a lot of different ways, though. It's not just the chemical cocktail combination and the risk of actually waking up in the middle of your execution and feeling the potassium chloride, burning out your veins. But it's also the lack of training and supervision and I don't care what Judge Stevens says about it, the medical personnel who are actually starting the IV lines and those kinds of things. That's what happened in Florida. It seems to be a training problem, and I guess the courts aren't going to be. I would hope that the courts aren't satisfied that we don't have an unreasonable risk of a torturous death. Unless these issues are somehow addressed, and that's really what we're doing. I have to tell you, as someone who's filed a couple of these, it's really uncomfortable to read these pleadings. That you're actually describing in detail for the court what each chemical is doing to the person as they're dying. I mean, it's very difficult. But there's an awareness, even as we're putting these together, that this isn't this isn't an abolitionist attack. I mean, we can't abolish the death penalty by attacking lethal injection. The best we can do, I think, is force states to come up with another way of executing people, which I'm sure they will, and or delay executions. And a lot of people say, oh, you know, that's just as bad, delaying executions. Well, but for the delay of some executions, we would not have discovered, you know, the kind of errors that exist in many of these cases. We have to often buy time in order to be able to continue the work we're doing on these cases and to discover the innocent clients, the clients who've been sentenced to death wrongly. You know, I have a client who we received a new trial for a year ago. He was on death row for 14 years, which is much longer than average. For North Carolina, it's about 8 to 10. But for the delays that we imposed in his case, this innocent man would be dead already. You know, so I don't, you know, that criticism is always kind of cuts me wrong, disturbs me.
Yeah, whether it's done by design or not, I mean, I think that, you know, a challenge to to lethal injection has an impact ultimately on whether the death penalty is abolished, because I think that, like everything else, it becomes part of the calculus that the public uses in determining whether it supports it, and at some point, it becomes so expensive to do relative to what people see as the benefit that I think that's going to be the basis on which the death penalty ultimately is abolished, which is that there are too few sentences and it costs too much per sentence relative to what it would cost just to keep the person in prison forever. I mean, as you know, the death penalty is not required in any case, so you know, it's totally consistent with criminal law to sentence every person tried for capital murder to life in prison. So if the overwhelming number of people are being sentenced to life in prison, and you can't tell the difference between those who are and those who aren't, then you're going to have to ask the question, and the court has done this, at least it did it in 1972, you know, this then starts to look arbitrary. And I think that as you challenge lethal injection, as you challenge, you know, other aspects of how the system works, it simply exposes to the public what's going on. I mean, I don't think most people paid much attention to the involvement of doctors in executions until these challenges, and then all of a sudden, you know, the role of the doctor gets exposed, and North Carolina has a system that requires the participation of doctors or medical people, and you know, that raises larger ethical questions. I mean, is that appropriate? And for the profession, this is not about the death penalty, but for the profession. So it becomes more difficult to do, and I think ultimately the public will just simply throw up its hands. I mean, one of the things that's also counterintuitive is that the death penalty relative to putting a person in prison for life is significantly more expensive. I mean, Phil Cook is going to talk about that here later, but you know, he did a study several years ago in which, you know, that's what he was able to demonstrate, that it costs significantly more to try to carry out an execution than simply to put the person in prison for life.
Do you all have time for one more question?
Yeah, we can do one more. I think there's one person.
One more question.
Well, with that being said, I mean, I've done studies too, and I found that it's more expensive to put someone in life in prison forever. Statistics can show whatever you want it to show. A lot could be motivated by who's doing the study and who's doing that. So have y'all done your own studies, or are you basing this on propaganda that someone else has done with a very set view against the death penalty?
Well, that's a good question, but I think the study was done by Professor Cook. He's redoing it now. It was in 1993, that was the last time it was done. So in $1993, with the state of the practice in 1993, it was costing $1.2 million. The statistics don't say anything else other than that. no statistics are showing that it costs more to sentence someone to death than it does to sentence someone to life. Now, of course, that assumes that you respect constitutional requirements for competent representation. I mean, if you and appropriate judicial review of cases. Now, if you don't find that has value, then of course you can do it much cheaper. I mean, if you don't believe that people deserve to have competent attorneys who are trained well, and judges who actually give evidentiary hearings on meritorious claims and provide relief when the Constitution requires it, if you just reject all of that, then you could just wait after the jury comes back with a death sentence. You could hang him in the courtyard, and that would be much cheaper. But that's the only way. It's the only set of facts that I've ever heard of that result in a cheaper application of a death penalty than putting somebody in prison for the rest of their life, because you don't have these you don't have the required review before execution.
There's an interesting case going on in Georgia now. You've read about it. It's a guy who was waiting for trial. He was in the courthouse waiting for trial, escaped, killed a judge and several other people in Atlanta, kidnapped the person, and she talked him into turning himself in. The trial has been postponed because Georgia decided that it was spending too much money on capital cases, and so it did exactly what Mark suggested, which was it said, we're going to cut the budget in half for capital cases, and that's what you're going to get. Because what was happening was that the people who were doing capital cases funded by the state were winning all of their cases in the sense that they were avoiding the death penalty. And so the governor decided that the way to address that is to cut the money. So the trial in that case has been postponed while they are now arguing about whether the state will have to pay the lawyers pursuant to an order that the trial judge entered a year and a half ago that set their fee. The state now wants these lawyers to handle the case at significantly less money, and so they have lawyers, the lawyers have lawyers litigating whether Georgia can do this. So it's going to be an interesting case to follow.
And remember, winning in a capital case means exposing a significant constitutional violation of a defendant's rights.
Right.
Often it's because sometimes it's because the person didn't do it, or sometimes because of prosecutorial police corruption, and other kinds of just really inappropriate kinds of conduct and behaviors that are going on in courtrooms today. So that, winning doesn't mean, technicality. It's just
Right.
the Constitution.
Thank you all for coming out here today. You all can join me in thanking our guests as well.